1, defendant appeals from a judgment convicting him upon a plea of guilty of driving while intoxicated as a felony and aggravated unlicensed operation of a motor vehicle in the third degree. In appeal number 2, defendant appeals from a judgment convicting him also upon a plea of guilty of sexual abuse in the first degree. We reject the contention of defendant in appeal number 1 that the sentence is unduly harsh or severe. We agree with defendant, however, that his plea of guilty in appeal number 2 is jurisdictionally defective because sexual abuse in the first degree is not a lesser included offense of any crime charged in the indictment. County Court was permitted to accept a plea of guilty to a lesser included offense with respect to any or all of the offenses charged in the indictment. The people concede that the offense to which the defendant pleaded guilty in appeal number 2 is not a lesser included offense with respect to any of the offenses with which defendant was charged in the indictment, i.e., sodomy in the first degree, sodomy in the second degree, and rape in the second degree. We therefore recognize and reverse the judgment in appeal number 2, vacate the plea, and remit the matter to County Court for further proceedings in the indictment. The record supports defendant's contention that County Court failed to set forth its reasons for expecting the statement made by the victim from the pre-sentence report as required. It is hereby ordered that the judgment so appealed from be, and the same hereby is unanimously affirmed. We therefore modify the judgment by vacating the sentence, and we remit the matter to County Court for resentencing, at which time the court shall either disclose the victim's statement to defendant or set forth its reason for exercising its discretion not to disclose the statement. It is hereby ordered that the judgment so appealed from be, and the same hereby is unanimously modified on the law by vacating the sentence, and as modified, the judgment is affirmed and the matter is remitted to Orleans County Court for resentencing. Defendant contends that County Court erred in sentencing him upon a felony conviction without ordering a pre-sentence investigation. The people concede that the investigation and written report thereon were not waived by the parties with the consent of the court pursuant to CPL, thus that the sentence must be vacated. We therefore modify the judgment accordingly, and we remit the matter to County Court for resentencing. It is hereby ordered that the judgment so appealed from be, and the same hereby is, unanimously modified on the law by vacating the sentence, and as modified, the judgment is affirmed, and the matter is remitted to Ontario County Court for resentencing. We conclude in appeal number 1 that the Supreme Court properly granted those parts of the motions of defendant Nationwide Mutual Insurance Company and defendants David E. Lehman and Linda Lehman seeking dismissal of the respective causes of action against them, alleging spoliation for failure to state a cause of action. See CPLR 3211, paren A. Plaintiff was asleep in a camper located on the property of the Lehmans when a tree limb fell onto the camper during a severe storm, causing her to sustain catastrophic injuries. Upon the completion of Nationwide's inspection of the camper and the property with respect to the claims of the Lehmans for plaintiff's injuries and the property damage, the Lehmans sought authorization from Nationwide to dispose of the camper and the tree limbs that had fallen. Nationwide advised the Lehmans in writing that its investigation, which included a report from an arborist and several photographs, was complete, and that it therefore had no further use for those items. The Lehmans arranged for the disposal of the camper and the tree limbs nearly 3 years before the instant action was commenced. We reject the contention of plaintiff that Nationwide is liable for failing to preserve the camper and the tree limbs, and thus that she has a cause of action against it for spoliation. See MetLife Auto and Home versus Joe Basel Chevrolet, 303 Appellate Division 2nd, 39 to 44. 753, New York Supplement 2nd, 272. Affirmed 1, New York 3rd, 478. 775, New York Supplement 2nd, 754. 807, Northeastern 2nd, 865. In addition, we reject the contention of plaintiff that she has a cause of action against the Lehmans for spoliation. We note, however, that the court has the discretion to impose sanction for the destruction of the evidence within the context of the remaining causes of action in the event it sees fit to do so. See CPLR 3126. See generally Miller versus Weyerhaeuser Company. 3. Appellate Division 3rd, 627, Miller versus Weyerhaeuser Company, 771, New York Supplement 2nd, 200. In light of our decision herein, we need not address the contentions raised in defendant's appeals.
Thank you.
That was better.